Good morning, everyone. Before we begin, we encourage you to take a moment to reflect and connect with the land that you are currently on and reflect on who the original occupants were. We recognize that many Indigenous nations have long-standing relationships with the territories upon which the Ontario College of Teachers reside, including the Wendat, Anishinaabeg, Haudenosaunee, Chippewa, Métis, and the Mississaugas of the credit of the First Nation. We are thankful for the Indigenous peoples who have cared for the land and the environment so that we can live and work here today. For centuries, they have shared their knowledge, art, and culture. We are sincerely grateful for the opportunity of sharing these lands for our mutual benefit.
Good morning. My name is Janice Duggan. I'm the Manager of Investigations in the Investigations and Professional Conduct Department at the college. I want to take this opportunity to thank you for joining us today as we discuss reporting obligations, a refresher, conditions, terms, limitations on member certificates, therapy and counseling, a refresher, professional advisories, member information on the public register, transitional certificate holders and what employers need to know, and the Sexual Abuse Prevention Program, or SAP. I'm going to introduce today's presenters. Patrick Winter is our Senior Intake Officer. Lisa DaCosta is an investigator with the Investigations Unit. Sarah Cunningham, Conditions Monitor and Public Register. And Nicholas Wallachuk, Policy Analyst. College staff will stop between topics to answer any questions that you may have. They'll also be available at the end of today's webinar to answer any questions. In addition, the information presented today will also be available on the college's website. And to be supportive of you going forward, we'll make these slides available to you in the coming weeks. I also know that we received a number of questions in writing. Most of those questions will be addressed in the course of the webinar. For the ones that are not going to be addressed specifically in the webinar, we'll address those at the end at the question and answer session. So let's begin.
Great. Thanks very much, Janice, and welcome everyone. Here you'll see just the list of topics that we're going to be going over today. Some of these will be refreshers for those of you who have been in your roles for a period of time, but I know that we always have a lot of new faces in the webinars, so let's get started with a refresher on employer reporting obligations. In 2020, the Ontario College of Teachers Act was amended to include new reporting obligations for college members. The following slide, duty to self-report with respect to offenses, will outline the section of legislation regarding a member's duty to self-report in relation to criminal matters. Members are required to report the following to the college: offenses, charges, and bail conditions or other restrictions. These reporting obligations took effect on December 8th, 2020. Failure to comply with these reporting obligations may be considered to be an act of professional misconduct. Again, you'll see here the reporting obligations listed if a member has been charged with an offense. When self-reporting, the member must include, among other things, the charge, when the charge was laid, and the location of the court in which the charge was laid. All bail or release conditions must be included in the report, as well as the status of any proceedings. It's important that the employer continue to report criminal charges or convictions to the college, as employers do have a duty to report these charges and outcomes under the Act, and some members may not fulfill their obligations to self-report. Aside from fulfilling your reporting obligations, it's important that you make these reports because the college is mandated under the Act to post criminal charges, bail conditions, or release conditions that restrict a member's eligibility to teach, as well as posting any convictions. The college's mandate is to govern the profession in the public interest and to protect students. Posting a member's criminal charges, applicable bail conditions, and convictions helps the college to fulfill its mandate by alerting members of the public to members who may pose a risk to students. So now I'd like to go on to section 43.2 of the Ontario College of Teachers Act, and the next few slides set out the statutory framework which governs your reporting obligations to the college and is a review of what's been provided in previous webinars. Such duties include an ongoing obligation to provide documentation or information to the college within specified timeframes. In a typical year, the college receives about 500 reports from employers under sections 43.2 and 43.3 of the Ontario College of Teachers Act. And if you could direct your attention to the slide on the screen, it states that section 43.2 of the Act states that if you terminate, suspend, or restrict the duties of an Ontario College of Teachers member for reasons of professional misconduct, you must notify the college in writing within 30 days. You must report even if the member resigns while you are conducting an investigation or compiling evidence. And section 43.3 of the Ontario College of Teachers Act stipulates that if an employee or former employee is charged with or convicted of an offense involving sexual conduct in minors, or an offense that in the opinion of the employer indicates that students may be at risk of harm or injury, the matter must be reported to the college within 30 days. Additionally, if a member has engaged in conduct or taken action that, in your opinion, should be reviewed by a committee of the college, you should submit a report. So we all know what constitutes a termination or a suspension. However, it may be less clear what constitutes a restriction of duties. To offer clarification, some other examples of restrictions may include removing a member from the occasional teachers list. It could include a transfer of a member to another school for disciplinary reasons, or blocking a member from teaching specific grades or courses. Section 43.3 is fairly self-explanatory, sets out various scenarios relating to duty to report as they relate to certain types of criminal charges and convictions. And please note that this section is written in such a way that employers must report members to the college if they become aware of these charges and convictions, even if the member is no longer working for the employer. And finally, I'd like to touch on section 277.40 of the Education Act. This section of the Education Act triggers the duty to report in relation to teacher performance appraisals or member resignations while on review status during the TPA process. So that section of the Education Act stipulates that if you terminate a member's employment following unsatisfactory TPAs, you must submit a complaint to the college. Additionally, if, like I mentioned, if a member resigns while they're on review status, then that triggers the reporting requirement as well.
Thank you, Patrick. We now have our first poll question of this interactive presentation, which we're going to launch now. So the question is a true or false question. If a member self-reports a criminal charge to the college, the employer does not have to report it to the college. So we will launch the poll now, and we'd like you to enter your answer whether you think this is true or false. All right, thank you so much for participating. All of you chose false, and the correct answer was false. Thank you, everybody.
So now moving on, I'm going to discuss now some of the information that should be included in our employer. So this is what should a report include? It should include, of course, the name and college registration number of the member. Should include a summary of the event or events that led to the report. It should include specifics of disciplinary action taken by the employer, and it should be. It is important to note that you should provide sufficient detail. I'd like to focus a little bit on the second bullet point, summary of event that led to the report. What we're looking for here is enough information so that we're able to make an initial recommendation as to whether an investigation at the college is necessary. So we need a description of the event or events that led to the employer discipline, not just a general form letter with limited information. By description, I mean some details as to what occurred. For example, rather than advising that a member used inappropriate language, it would be useful to know exactly what the employer has indicated that the member said. If necessary, we can follow up with you to get further information, but ideally some details should be included in the initial report. So for instance, don't do this. John Doe was suspended for 2 days for inappropriate communication and inappropriate physical contact involving a student. That doesn't provide us a whole lot of context or detail as to what happened. So do this instead. John Doe was suspended for 2 days for grabbing a student by the arm and dragging the student out of the classroom. He called the student stupid and yelled at the student to shut up. So now we're going to move on to how to submit a report. The information you're seeing now is how reports may be submitted to the college. Now more than ever, we prefer to receive reports by email. If you do report by email, it is not necessary to send a hard copy of the same report. To ensure that the college has received the report, please ask in your reporting email that college staff acknowledge receipt of your email. And we would like to remind you that the college does have a fillable employer report form. This is a PDF that can be submitted. It's not currently available as an online form. The college's investigations and professional conduct department is routinely looking for ways to make the reporting process easier and more efficient for employers. The fillable employer report form provides an outline of all information that's required by the college when an employer submits a report. It can be completed and submitted to the college along with any necessary documentation to our email address ipc@oct.ca whenever a report is required. Please note that it's not necessary to use this new fillable form. It is being provided for you for your convenience should you wish to incorporate it into your existing reporting procedures. If you have any questions about this form or if you'd like a copy of the fillable form, you can contact the college's intake unit at ipc@oct.ca and we would be glad to assist you.
Thanks, Patrick. So if the matter moves forward to investigations, you will receive a letter and a checklist asking for further information relating to the report and also the member's discipline and conduct history with the employer. We will speak more about the latter point in a few moments. You are required under the Act to provide the college with all documentation relating to your report within 30 days of submitting your report to the college. We suggest you start assembling the information immediately following your report to the college to meet the 30-day timeline. When there are delays in providing the information with no notice or explanation for the delay provided to the college or general unresponsiveness, the Director of Investigations and Professional Conduct or the registrar may contact the employer's Director of Education or equivalent at a non-publicly funded school. The college recognizes that there will be occasions when providing the information within the 30 days may not be possible. If that's the case, please contact the Manager of Investigations, whose contact information is set out at the end of this presentation, to discuss an extension. Now let's do a quick review of the documents required by the college following an employer report. As noted, the college requires information and documentation pertaining to a member's previous disciplinary and conduct issues. So why do we ask for that information? Well, sometimes when employers are reviewing a member's history, they discover that a matter should have been reported to the college was not. For example, a member was suspended, but through an oversight, the matter was not reported at the time. This is an opportunity to alert the college to that prior suspension. Or sometimes a member's prior conduct issue did not lead to a mandatory reporting obligation, but in light of the current report, it may represent a pattern of conduct. The college is attempting to get the complete picture regarding the member in order that the investigation committee may make a fully informed decision. And what information is the college routinely seeking? We're seeking all underlying investigation information and documentation, such as principal and vice principal's investigation notes, witness statements, including those of any alleged victim, investigation findings and reports, disciplinary letters, and all relevant correspondence, including email, text, or social media messages. Each case will yield different information that was gathered during an investigation, depending on what the allegations were. But what I just listed is typically found in all investigations. The college also requires the member's current employment status and the dates of changes to their status. For example, has the member retired from the board or the employer? Has the member gone on a medical leave? The names, addresses, and contact information for school and board staff who were involved in the investigation and those of any affected students and student witnesses are also required. Please do not send redacted documents. If a matter is referred to investigations, the assigned investigator will redact the documents as appropriate before they are disclosed to the member who is the subject of the investigation. If redacted documents are sent, this will lead to the investigator sending a follow-up inquiry seeking the unredacted materials. Under the Act, any information that an employer provides to the college must also be provided to the member who is under investigation. So if you have questions or concerns about sending unredacted materials to the member who's a subject of a report to the college, you should consult your legal counsel for advice. For TPA matters, the college will require a copy of all of the summative reports for the member and any materials relating to the TPA process, such as the principal's observation notes and improvement plans. You may wish to go to the employer's area portal on the college website, where you can obtain further information concerning employer obligations. Also, most of you are probably aware of the checklist that you receive when the college acknowledges receipt of your report and writes to ask you for information regarding that report. The checklist sets out what documentation the college is requesting from you. If you are not familiar with the checklist, please send us a note in the chat and we will get back to you with this information. Finally, I'll add that as noted, when you receive the checklist, we ask for the member's discipline and conduct history. Often in response to that request, we have only received letters associated with measures taken against members. Now that's helpful, but just as we would with the current report, we would also like to receive any underlying information related to your historical investigations. So basically, we're asking for the same information that we would expect to see in a matter being reported by you under your Section 43 reporting obligations. Note that any information you send to the college as a result of the checklist or as requested by the investigator must also be provided to the member within 30 days of sending it to the college. This is a statutory obligation with which all employers must comply. As noted, if you have any questions or concerns about sending unredacted materials to the member who's the subject of a report to the college, you should consult legal counsel for advice. Once you have provided all of the information identified in the checklist within the 30-day timeline, the investigator will determine if any additional information is required. As indicated in the slide before you, the Act requires that such information be provided within 15 days of the employer receiving the second request. And as noted earlier, it is important and appreciated if employers advise if they will be unable to meet a deadline. There may be a good reason to request an extension, and the college is open to considering such requests. If you encounter any issues meeting the 15-day deadline for additional information requested by the investigator, please contact the investigator assigned to the investigation to discuss an extension. The college wants to keep the lines of communication open, so please do contact us if a problem arises with the timelines. As noted on this slide, the college receives frequently asked questions about what materials should be sent to the college. The college is often asked if audio and video materials should be sent. The answer is yes. Any relevant audio and visual recordings must also be provided. So for example, this would include video recordings of a hallway incident or a video received from a student in relation to an incident involving a member. The college is also asked about notes and what is required. The college requires any notes, handwritten or typed, related to the report, such as the opportunity to respond meeting notes, any interview notes, principal's notes, vice principal's notes, etc. Please ensure that the notes are dated and it's clear who authored the notes. Regarding interview notes, prior to commencing an interview, please be sure to include for each set of notes the author and title of the person taking the notes, the full name and title of the individuals present at the meeting or interview, the date, so month, day, year, and start and end time of the meeting or interview, the location of the meeting or interview, subject matter of the interview, and please make it clear what incident or incidents you are discussing at the meeting. Please also identify the date of each incident in question. This includes the month, day, and year. So if the reported conduct occurred over a longer time frame, please identify the date as best as you can, or include a broader time period, such as in or about the spring of 2021 or in or about March 2021. And as mentioned, we would appreciate typed notes, or if that is not possible, please ensure legibility. I want to touch on documents which are sent to us in the form of screenshots. We often receive screenshots of electronic messages. So for example, email threads, text messages, and social media messages with information that is missing. Please be sure to identify how the screenshot came into your possession. So for example, on October 1st, 2023, a student named John Doe showed the school principal text messages she had exchanged with her teacher, John Smith. On October 2nd, 2023, the school principal took notes of the screen of Jane Doe's phone, which displayed those text messages. Please note that settlement agreements between employers and members will often contain a provision indicating that the agreement can be disclosed if required by law. The Ontario College of Teachers Act is a law that requires that this information be disclosed to the college. Please also note that that employers cannot enter into any agreement, including minutes of settlement, with a member which includes an undertaking that is contrary to your reporting obligations under the Act. For example, employers cannot agree not to report a matter that under the Act is a mandatory report to the college. Also, in settlement agreements, employers cannot agree not to fulfill its obligations to provide information to the college in relation to a report to the college. Your reporting obligations under the Act cannot be contracted out. So any settlement agreement that agrees to remove an employer's reporting obligations to the college is invalid. While you as the employer may have settled a matter with a member by having, for example, the member resign from their employment, this does not end the employer's obligations to the college. And finally, please do not write to the college to advise that a matter between you as employer and the member has settled and you are requesting that the college close its file. The college will not do so. Under the Act, the college has a public interest mandate to govern the profession, and part of that mandate is to investigate allegations of professional misconduct, competence, and fitness to practice. We're often asked about what information should or can be redacted from documents sent by employers. When the college requests information from employers, it is essential that we receive that information in its truest form without redactions. Oftentimes, we receive employer information with student names, ages, and grade levels, and contact information redacted. We also receive employer information that has the contact information about the parents of the student witnesses redacted if the student witnesses are minors. I know I'm repeating myself, but please only send unredacted documents. We require this information for the purposes of our investigation. Additionally, the college sometimes receives employer information without the student witness contact information. Please ensure that the contact information is included. There may be a reason for contacting the students during the college investigation, so that information is important. Some employers have voiced concerns regarding confidentiality over this type of information. We want to assure you that this information remains confidential. Contact information is redacted from disclosure made to the member. The college does not disclose student witness and/or student victim contact information. However, we do disclose student witness and alleged victim names. We provide that information to the member because the college has a disclosure obligation to the member during the investigation process. As a matter of law, the member is entitled to have all relevant information in order to provide a response to the complaint. When conducting an employer investigation, please do not give members and/or witnesses any assurances of confidentiality. You will be required to provide the college all interview notes and contact information as part of your statutory duty to provide information to the college. And as noted, the college is obligated to disclose all of that information to the member during the course of its investigation. Therefore, any assurances of anonymity should not be given to a witness or an alleged victim. Without that information, a member may be able to argue that he or she could not fully respond to the complaint. the college has received questions about sending password-protected documents. Please do not send password-protected documents to the college. The college's email system is secure and confidential. And as stated earlier, the college does not require hard copy of employer information packages. The college's strong preference is to receive an electronic version of the employer materials. Also, please ensure the documents that are sent are clear and legible. So some points to note. Please note that the timelines specified in the Act remain the same regardless of your academic calendar or closure period. Also, the Ontario College of Teachers Act does not allow the college to delay an investigation when there is an ongoing grievance or arbitration. The employer discipline process and the college's investigation process are two separate processes. While we may follow up with you to determine the status of agreements, that is to ensure that all of the up-to-date information has been gathered for the investigation committee.
Thanks, Lisa. So now we're going to go over a couple more frequently asked questions that we receive with respect to reporting obligations. The first one is, do I have to report when an employee goes on a medical leave of absence? In and of itself, no, you do not. An employer's reporting obligations under Section 43 of the Act are triggered due to a suspension, restriction of duties, a termination of a member's employment for reasons relating to professional misconduct. When the member goes on a medical leave of absence in the course of an investigation and you are uncertain whether the member's conduct constitutes professional misconduct, you can report the matter to the college. Next question is, do I have to submit a report to the college when a member is assigned to home pending the outcome of an investigation by the employer? This is a question that we receive quite often. It's not necessary to report that a member has been assigned to home pending an investigation. However, if the investigation concludes and the member faces a disciplinary restriction of duties as defined in Section 43.2 of the Act, the matter must be reported at that time. The next question is, if the employee goes on a medical leave during the board or school investigation regarding the conduct, am I required to report this to the college? Reporting this means in this case, reporting the fact that the member did go on a medical leave. The answer to that question is going to be yes, as this may have relevance as to how the investigation committee chooses to deal with the member.
Next question is, what is the employer's reporting obligation when a third-party investigator is hired to conduct an investigation of a member? The answer is the college receives employer notifications where a third-party investigator has conducted the investigation. In some of those situations, the employer has entered into an agreement with the third-party investigator that permits the investigator to have ownership of its underlying investigation product. While the employer will provide the third-party investigator's final report, it is not able to provide the underlying investigation materials, such as the investigator's interview notes, because of the agreement signed with the investigator. As noted above, please remember your obligation to provide information to the college when retaining third-party investigators. So the difficulty with not having the underlying investigation materials is twofold. Firstly, the member who is under investigation may argue that they are not able to provide a full response to the allegations. Secondly, the investigation committee panel that considers the matter may not have all of the information necessary to make a fully informed decision. I'm going to turn it over to Sarah, who will go over certificates with terms, conditions, and limitations.
Thanks, Lisa. Sometimes the college's discipline committee, investigation committee, and fitness to practice committee order terms, conditions, and limitations, referred to in short as TCLs, that are placed on member certificates. These TCLs will require members to meet certain requirements. These requirements can include completing a course, providing a copy of a teacher performance appraisal to the college, or meeting with a medical practitioner and provide results of that meeting to the college. The TCLs are tailored to the outcome of the individual matter addressed by the committee and are intended to ensure that members may return to the profession with the necessary tools, training, or support to prevent a reoccurrence of whatever conduct or to manage whatever condition led to a referral to the college in the first place. Here you can see the steps that occur once a committee of a college has ordered TCLs to be added to a certificate. This slide shows the process of when a committee orders the completion of a prescribed professional learning course. TCLs that require submission of TPA outcomes or medical information, of course, have different steps, but overall the process is similar. The committee will order the TCLs, and the member will be responsible for fulfilling the requirements. In December 2020, Section 23(2)(b)(5) of the Ontario College of Teachers Act was changed and requires that all discipline committee decisions and TCLs remain on the public register. Once fulfilled, the TCLs will be updated with a note. Some TCLs will require a completion within a certain period of time, as shown in this example. College staff will monitor these conditions, and failure by a member to complete the requirements may result in disciplinary action by the college. Some TCLs do not have a deadline attached to their required completion, but rather must be completed before the member returns to the profession. As you can see in this example, this member must complete a course on classroom management and anger management prior to returning to the profession. Here are some best practices that should be followed if you employ a member whose certificate is subject to terms, conditions, or limitations. First, always review members' profiles on the public register of the college's website. If a member has active conditions, ask the member to contact the college to complete their conditions so that the public register can be updated. If there are any questions or doubts about what's on a member's certificate on the public register, please contact the college for assistance.
Thank you, Sarah. We now have our next quiz question, number 2. I'll read it out before we launch the poll. So, true or false, terms, conditions, and limitations imposed and fulfilled after December 8th, 2020 can be removed from the public register. So, true or false, we will launch the poll now. Okay, we will end the poll. So we have 38% who said true and 62% who said false. And the correct answer was false in this situation. Thank you.
On some occasions, members of the public and employers identify teachers who are the subject of a report to the college by one surname, while the college's records have the member using a different surname. This can cause some confusion about identifying who is being complained about. College staff make every effort to ensure that the correct member is identified, but it would assist matters if you could remind your OCT staff that they have obligations under the college's bylaws regarding information that they must provide to the college. The next 2 slides set out some of the information members are required to provide to the college. So Section 19 of the bylaws sets out requirements regarding members' names. The slide draws attention to Section 19.01 that states that the member's name on the register shall be the name on the member's application for registration, subject to certain exceptions. The one that is highlighted is Section 19.031. Where a member changes their name, they have an obligation to forthwith notify the college of that name change. The college sometimes runs into the issue of members not advising of their current employer. Again, this slide sets out part of Section 25 of the bylaws and the information that members must provide to the college. This includes their current employer and the member's current contact information. And these parts of Bylaw 25 also set out obligations regarding names. Again, it would be appreciated if you could remind your OCT staff of these obligations.
Thanks, Lisa. So now I'd like to move on to the college's therapy and counseling funding program, and this will be a review for those of you who have been in previous recent webinars that we've hosted. But it is an important program, and I would like to go over it again. So the college has introduced a program to help defray the costs of therapy and counseling borne by students who allege having been sexually abused by teachers involved in child pornography or a prescribed sexual act. If a student has been sexually abused or was the subject of a prohibited act involving child pornography by a member of the college, help is available. Victims, parents, guardians, and siblings can apply for funding to help pay some of the costs of therapy and counseling. The Ontario College of Teachers will make funding available to help cover survivors' costs for therapy and counseling. Approximately $18,000 can be claimed. This amount is equivalent to what the Ontario Health Insurance Plan would pay for 200 half-hour sessions of individual outpatient psychotherapy with a psychiatrist. So if you or your staff encounter scenarios where it might be appropriate to make a student or a former student aware of the program, please advise them to contact the college, and we'd be happy to provide information about applying for funding. The application and claims processes are very straightforward. College staff are available to help survivors in a compassionate and understanding manner.
So before Patrick goes over this section, we were going to launch our third and final poll of this presentation. So the question is, multiple choice, how many professional advisories has the college published? And your choices are 4, 7, 9, or 11. So I will launch this poll now and ask you to participate, please. Thank you for participating in the poll. The majority of you did get the correct answer, which is 9. So we have 60% of participants. Thank you so much for participating in that poll.
Developed, as Ryan noted, 9 professional advisories that provide practical advice to members on a variety of topics important to members of the teaching profession. We recommend that school administrators review these advisories on a regular basis with their teaching staff in order to maintain familiarity with their responsibilities in a variety of areas relating to their work. So based on complaints and reports received by the college, all members of the profession should be familiar with the following professional advisories. The first is maintaining professionalism, use of electronic communication and social media. This advisory helps to clarify members' responsibilities when using electronic communication or social media so they can govern their conduct and understand what conduct does not meet professional standards. The next is professional boundaries. And this advisory highlights the importance of maintaining professional boundaries and provides practical advice to Ontario certified teachers at any point in their education careers. After that, we have professional misconduct of a sexual nature. This advisory helps to identify the legal, ethical, and professional parameters that govern members' behavior and to prevent the sexual abuse of students and sexual misconduct. And finally, on this list, we have professional advisory on anti-Black racism. And this advisory recognizes that Ontario certified teachers play an important and influential role in learning environments, and as such, they're uniquely positioned to help address anti-Black racism and its impact on students. The advisory examines how members can work toward overcoming longstanding and historical legacies and break down deeply entrenched systemic barriers. All advisories are available on the college's website and can be downloaded as PDF files for distribution.
Thanks, Patrick. From College Communications, you are no doubt aware that a new transitional certificate has been introduced. We are not planning on providing extensive information about the certificate, but rather some key points to be aware of with respect to an employer's obligation as they relate to reporting matters to the college. So standards and responsibilities. Transitional certificate holders are members of the college. They must adhere to the standards of practice and ethical standards of the profession. Any transitional certificate holder that engages in professional misconduct is subject to investigation discipline at the college if they engage in misconduct, and could result in public hearings and sanctions up to and including terms, conditions, limitations, suspensions, and revocation. They could also be subject to complaints of incompetence or incapacity. Transitional certificate holders are subject to college jurisdiction at all times, including on practicum and while employed as a teacher. And like any other member, transitional certificate holders may be subject to the employer's mandatory reporting obligations that we discussed earlier in the presentation. Employers are required to report to the college cases of restrictions on practice which arise out of a disciplinary process, as well as criminal charges and convictions that involve sexual misconduct and minors, or actions that pose a risk of harm or injury to students in the opinion of the employer. Employers may also report any matter that they think should be reviewed by a college committee. So in short, any reporting requirement that was discussed earlier in this presentation applies to transitional certificate holders. I'm going to turn it over to Nick now, who's going to go over the sexual abuse prevention program with you.
Thanks, Lisa. So since January 2022, the Ontario College of Teachers Act has required all Ontario certified teachers and new applicants to the college to successfully complete the Sexual Abuse Prevention Program, or the SAP. The SAP consists of a series of video modules, each with a distinct focus on subjects that include information on how to recognize when a student may be disclosing that they have been abused. On September 19th, 2023, the college provided all boards with the names and member IDs of their OCT employees who have not yet completed the SAP. The college will be providing updated lists to boards towards the end of March or beginning of April. While members who have not yet completed the SAP remain in good standing, the college is actively considering compliance measures that may affect a member's certification and ability to work in Ontario's publicly funded education system. A few notes about the SAP: it is free of charge. It can be completed online by signing into a member section of the college's website. It takes about 3 hours to complete. It can be done all at once over multiple sessions. And members and applicants require a score of at least 80% to pass. Accommodations, extensions, and exemptions. Members can request accommodations to help them complete the program by contacting the Canadian Centre for Child Protection. Some of the accommodations provided by the Centre include a written format to complete the SAP instead of the video-based module, access to an introductory video to the SAP content, and access to a support telephone, including examinations by telephone. Extensions for current OCTs are no longer permitted, except for Ontario Labour applicants who must complete the program within 1 year of their certification date. And exemptions were never permitted and are not permitted now. The college recommends that you follow up with your employees who have not yet completed the SAP, as well as with their respective affiliates, federations, and/or principals council.
As noted earlier, to support you, we will provide you with a copy of the slides and a link to the recording of this webinar via email in the coming weeks. We'll also include a link to any online survey in the email. Please, sorry, not any, an online survey. Please feel free to complete the survey, as your feedback is important in planning future webinars. Before I invite participants to share their questions, I'm just going to quickly address, I believe, the 2 questions that were not covered off in the webinar itself. One was, there were 2 related to investigations. One was the timelines for investigations and the average length of an investigation. It's fair to say that given the incredible increase in complaints and reports to the college that we've experienced over the last 2.5 years, that employers have also been experiencing an uptick in issues where they've had to investigate and discipline members. The college strives to meet its obligations to be timely in its investigations, but it does depend on a number of factors, including when we receive information from an employer, when we receive information from a public complainant, when we receive information from third parties such as police or courts or child and family services. Having said that, we have encountered, as perhaps many of the employers who I've spoken to over the course of the last couple of years, because of this uptick, we've experienced challenges in trying to complete things in as timely a fashion as possible. But we do make our best efforts to do that. In terms of the average length of an investigation, that's hard to say because each investigation is very different. During COVID, obviously, everyone experienced challenges in terms of dealing with at the school level, just teaching and the virtual world, and we experienced difficulties obtaining information because of closures and lockdowns. But we continue to make our best efforts to dispose of things in a timely manner. But we acknowledge that we face challenges. If there are particular cases that prompted that question or those questions, feel free to contact me. My contact information will be displayed at the end of the webinar, and I'm happy to discuss particular cases with you. The other question that was asked was about support services for teachers that may be offered through the college. The short answer to that is there are no support services offered through the college for members of the profession, including ones who are the subject of an investigation. But we highly encourage you to encourage your staff, if they are the subject of an investigation or otherwise need support in some manner, to contact the appropriate affiliate who will be able to direct them to those resources. There is my contact information as indicated. If there's a question about a particular case, I'm happy to discuss that. Please contact me by email and we'll set up a time to chat about that. If there are any other questions, happy to address those now. See something in the chat. I see something from Justin Jeffrey. Are there any details that you're able to share about consequences timelines for folks who have not completed SAP? So I'm going to turn that over to Nicholas and he'll address that.
Thanks for the question. Right now, the short answer is there is nothing on the books in terms of consequences for members. But as I mentioned in the presentation, there are discussions that are ongoing, and I wouldn't be surprised if additional details about consequences and timelines are revealed at a later time. So please do keep an eye out to any correspondence or publications made by the college. But at this time, the short answer is not yet. Thanks for the question.
I'm not seeing any. Am I missing any in the chat?
Nope, no questions have come through in the chat so far.
Okay, I don't see any raised hands either. All right, I'm going to take this opportunity to thank everyone. I know everyone is very busy, but I appreciate you taking the time out of your busy day to attend the webinar. And I want to thank. Oh, sorry, we have one other question about the SAP. Garfield is in a private school and wants to know how the SAP applies.
So the SAP applies to all OCT registrants. So regardless of where they're employed, whether it be in a public system or in a private system, or even just employed by a private or public employer that's not related to education, it is a requirement of licensure of membership to have completed the SAP. So it applies regardless of where you work. And then I think there's a follow-up. What supports is OCT members, providing members that are being triggered by SAP. So I mentioned in the presentation that there are accommodations provided through the Canadian Centre for Child Protection. and those accommodations are provided directly through them. So I would encourage any member who requires an accommodation to contact them directly. Thank you for both questions.
So we may have exhausted the questions, but again, I just want to extend my thanks for everyone taking time out of their busy days to attend this webinar. We appreciate the participation. I want to also thank all of the presenters today for their contributions and attendance. And again, thank you for attending the webinar, and we will be posting the appropriate information to you in the coming weeks. Thanks very much and take care.